everyone. I'm Uma Pemaraju. Welcome. Great to see you today. We are going to update you now with the George Zimmerman trial. What's happening right now is that the court is in recess till Monday. That's when we will start hearing opening statements from both sides. This has been a case that, of course, has been dominating the headlines. Let's go to Phil Keating for an update on where things stand in this trial so far. Phil?
A major milestone accomplished in the Seminole County Courthouse this morning. The very final pre-trial hearing wrapped up, and Judge Nelson then told both sides, we'll see you Monday morning, 9 a.m. for opening statements. So no more pre-trial hearings. We are going to get to the nitty-gritty, the meat of the matter, Monday morning as we hear both sides give their opening statements, and then we begin the state's parade of witnesses and testimony, and this jury of 6 women, 5 white women, 1 Hispanic woman, and the 4 alternates will all be listening in. Of the alternates, 3 are white, 2 are women, 1 of the men is Hispanic as well. So it's a very predominantly white jury, and as far as the core 6-person jury goes, it is all women who will be deciding whether George Zimmerman committed second-degree murder or acted in self-defense when he shot and killed Trayvon Martin in the heart with 1 bullet from his concealed handgun on the night in the dark, in the rain, in a gated community, February 26, 2012. The other big milestone, of course, accomplished yesterday, and that was the selection of the jury pool after contentious 7 days of divisive arguing and questioning by the attorneys of the select group of 40 jurors. So now we move forward with that. There was some major pieces of business also discussed today in the pretrial hearing. Number 1 dealt with inflammatory language. The defense of George Zimmerman wanted the judge to prohibit certain words and phrases from being used by the prosecutor in his opening statement, and the judge sided with the defense in disallowing the prosecution to use the term racially profiled. They cannot say that, however. The judge said they can say the word profiled, they can use the word vigilante, and they can also use the term wannabe cop, as well as the phrase, he confronted Trayvon Martin. The defense was trying to get that tossed today, arguing it yet again. Mark O'Mara, defense attorney for Zimmerman, and the judge said basically he confronted Trayvon Martin. That's essentially the state's case. She's going to allow it. As for the potentially conclusive testimony of these audio experts, enhanced audio experts, who have been analyzing and sampling the background screams heard in an infamous 911 call made that night in February last year by a neighbor as Trayvon Martin and George Zimmerman are fighting outside of her window. You can hear screams in the background. Experts have testified that there's only 3 seconds of the entire recording where you don't have 1 or 2 voices trampling on top of the screams. Well, the state says they have their own experts that say that's definitely Trayvon Martin screaming for help, including 1 expert who claims he can discern Trayvon Martin saying, quote, I'm begging you. But the defense claims, number 1, they have their own expert that says it was Zimmerman screaming for help. And they also cite numerous audio experts who say you simply cannot decipher this piece of tape and determine without a doubt who was the one screaming. In fact, last summer, the FBI's audio analysts basically gave up, saying the quality of the tape is poor and the sampling is too small. Plus, you're trying to compare a recorded normal talking voice with a scream, a hysterical scream in the background of an audio tape. They say, so the judge is going to rule on that admissibility either by 5 o'clock today or perhaps over the weekend, perhaps even as late as right before 9 a.m. Monday morning. Ilma?
We're all waiting to see what that ruling will be, because certainly it will have a big impact on the case. Phil, talk to me for a moment about the reaction from the Martin family so far about the jury and the fact that it is a panel of 6 women.
Well, the Martin family did release a statement. The parents of Trayvon Martin, Sabrina Fulton, his mother, and Tracy Martin, his father, and they said, you know, in this country, justice essentially should be colorblind. It is not a white panel that we wanted. We don't want justice in a black form. It's American as far as an equal playing field, and they certainly are expressing their comfortability with moving forward with no blacks on the panel. Of course, Trayvon Martin was a 17-year-old black teenager, but they do say that they expect this jury will be fair and impartial, and after 7 or 8 days of really thoroughly quizzing these jurors. We now have this panel of 10, 6 jurors and 4 alternates, all of whom actually said they could be fair and impartial and keep an open mind.
All right, Phil Keating, thank you so much for that update. We really appreciate it. We will be looking forward to your reports come Monday. Thank you very much.
All right. Thanks, Uma.
All right, let's talk about what happened today in court and what lies ahead for the upcoming trial. Joining us now, we have Mark Furnish, who's a criminal defense lawyer. He is here with us in studio, as well as Tamara Holder, who's a criminal defense attorney as well and a Fox News contributor. Welcome to the both of you. Great to have you here.
Hi, Uma.
Let's talk for a moment of the fact that the judge has yet to make this ruling about whether or not those voice experts will be allowed to testify. So much is riding on that. What do you think, Tamara?
Yeah, absolutely. This is a case without a lot of evidence, with really no evidence, if you think about it, compared to what the CSI type of person wants to see. They want fingerprints, blood prints, DNA, all of those things. It's all missing here, and that's why this video recording is such a big deal. This case hinges upon one person's testimony, George Zimmerman, if he testifies, and a video recording here and there, and maybe the coroner's report. Other than that, we don't have anything.
Mark, you agree?
Well, you know, Uma, what we're talking about here, the tape is going to come in, as I've said on this program in the past. What's at issue is the experts' conclusions as to what is said on the tape. So this pretrial Fry hearing, is what it's called under the law, is to determine the reliability of the methods that the experts are using, not their conclusions. And the Fry standard, our viewers should understand, is a very low admissibility standard. My colleague is right to the extent that there's a paucity of evidence in the case, very little, and I think the tape is important, and the experts' conclusions, to the extent they're allowed to express them, will also be quite important. I would expect the experts to be permitted to testify, given the fact that it's a very, very low evidentiary hurdle for the prosecutor to meet to establish the reliability of this methodology. And this type of audiology, the enhanced audiology, is commonly admitted in most federal trials that I've been involved in.
Today, the judge ruled that the word profile could be used, but not the word racially profile.
Solomonic justice,
yes,
or injustice, as it were.
So that means, for example, they can use certain words as, like, talk about the age or clothing before he attacked Zimmerman, and the fact that they don't want this to be a polarizing situation. It already has become that. But by taking that word out, do you think that makes much of a difference, Tamara?
I think it's smart. The judge has to be very careful here for her own reasons, aside from the four corners of the courtroom and affecting the jury and the jury pool, and also the outside responses. It's just simply smart for her to limit a word that could be possibly prejudicial or have more of an impact than other parts of the case. So let the jury come to their own conclusions based on profiling, instead of having that racial word in and risking a public backlash, risking the safety of herself or of other jurors. So it's important that she just left it out.
Other words that she is prohibiting are words like vigilante, wannabe cop. Those are words that are also being excluded in this trial.
I don't think she went far enough. I don't understand what profiling has to do with this case. This is a word that the Martin family lawyers, a buzzword, a loaded word, that the Martin family lawyers have injected into the trial. I mean, police officers profile or do not profile. It's not illegal for someone who's not an agent of the state to engage in profiling. It's a red herring, has no place in the state, in the case at all. Again, profiling is a practice that we can debate. It's being debated downtown in our stop and frisk trial here. It's a practice that police officers engage in or do not engage in. Some kind of private individual working for an ad hoc neighborhood watch group is incapable, factually or legally, of engaging in profiling. He's just, that's the whole problem with a neighborhood watch group. They can do or not do whatever they want. So there's no profiling.
I respectfully disagree, because taking you're taking the legal meaning of profiling.
Well, it's a trial, so it's a court of law.
Correct. I understand that it's a trial, but there are words that could have a certain legal meaning, but also have a separate meaning outside of the courtroom, and have a
How about he
meaning
singled
to.
them out on the
Let me
basis of
finish.
his
I
race?
allowed you to finish your point.
Yeah.
Let me just finish. So the judge has to be careful that even though there are legal terms to the word profiling or a legal meaning to racial profiling, and he is not a police officer, he is not an officer of the state or the city, he is still not. Other people are still allowed to engage in profiling. It is something that people do all the time. If our fellow Fox News contributor Juan Williams got fired from his job for saying something like that he saw a Muslim on a plane, that is human nature in profiling. Whether you agree with that or not, we do it every single day, and it is not necessarily the legal term, but it is a term that we use.